The federal government of Nigeria says it has drawn up a memorandum of understanding with significant inputs from all stakeholders to end the debilitating strike by the Judicial Staff Union of Nigeria, Judicial, and the Parliamentary Staff Association of Nigeria when conciliation resumes today. While providing insight into the conciliation effort of his joint committee on the dispute, Minister of Labour and Employment, Senator Chris Ngige, describes the MOU as a product of week-long consultations with all the critical stakeholders. Dr. Ngige said that as the chief conciliator, he has worked together with the Secretary of the Presidential Implementation Committee on the autonomy of the state judiciary and legislature, Senator Ita Enang, to consult all the stakeholders, including the chairman of the Nigeria Governors Forum, Kayode Fayemi, chairman of Northern Governors Forum, Simon Lalong, as well as officials from the Governors Forum Secretariat, chairman of Speakers of the State Houses of Assembly, as well as the administrative secretary of the Conference of Speakers of State Houses of Assembly. He also added that discussions were further broadened to bring in the leadership of the judiciary at the center and at the states.
Well, for more on this story, we've got the first Vice President of the Nigerian Bar Association, AIKPOKPO Martins, in our Abuja studio, while BENARD ONIGAH, the Secretary of the National Human Rights Committee of the Nigerian Bar Association, is with us in the studio. Good to have you both, gentlemen.
Thank you.
Okay, maybe I'll start with you, Mr. Martins. Thank you for being with us. With regards to the Memorandum of Understanding, are you confident that this memorandum will put to bed some of the thorny issues that led to the strike in the first place? What are your expectations?
Well, I would think that the statement by the Minister of Labour is premature for now, because at the last meeting of the stakeholders held, I think upper Thursday, the proposals of the governors was placed before the meeting, and if you recall, Judicial said that they need time to consult. As of yesterday, they have made their position known to the Minister of Labour, and I was privy. As of yesterday night, we broke up in our meeting with the Judicial national officers, myself and the national president and the president of the Nigerian Bar Association, were with the Judicial officers here about 9 o'clock yesterday, and they see a point of disagreement from Judicial, which we hope that today's meeting we reconcile. But for now, to say that there's a memorandum of understanding on the table, I think it's premature for now until after today's meeting.
Okay, Bernard, let me bring it to you. Help us understand and weigh in on the pros and cons of this strike by Johnson. While Johnson is accusing the governors of lack of financial autonomy for the courts, this strike is depriving people of their fundamental rights to access the courts. Make sense of it.
I have said time and time again that this strike is not about Johnson and the state governors. It is about the Nigerian people who go to the courts to seek redress and to seek for justice. So we must get the facts right that Johnson is protesting and is undertaking a strike on behalf of the larger society, on behalf of yourself seated there too. We are saying that it is not right for the governors to pay the salaries of judges and magistrates, and that there is no equality when we appear before them, and that we feel that the slogan that he who pays the piper that takes the tune will come into play, and that it is not good enough for the administration of justice. That is simply what we are saying. So we must take away, we'll be mentioning Judicial. No, the strike is about you and myself, and the state governors who have refused to allow constitutional provisions vis-a-vis allowing the judiciary to determine, control, and put up its budget for the year. It is money we are talking about here. Why are the governors bent on controlling the budget of the judiciary? It means their pecuniary interest that they take from undertaking that exercise. And we are saying that it is unconstitutional. So Judicial is on the side of the Constitution, and the NBA is on the side of the Constitution, and we are asking the governors who were elected by the same Constitution to be on the side of the Constitution. So I think we should begin by laying a robust foundation about the strike action. That is very important.
Okay, we haven't finished with the strike action necessarily, but I just want to touch on a fallout of the strike, a certain decongestion exercise which led to an unfortunate incident. Mr. Martins, can you help us situate it? What were magistrates doing inspecting police cells?
Yes, if you recall, under the administration of criminal justice law of Lagos State and indeed of all states, the magistrates are empowered to visit police stations and all other such stations where detainees can be held at least once a month. And having regard to the fact that the judicial strike was taking its toll on criminal justice administration, the chief judge of Lagos State, in conjunction with the Nigerian Bar Association and some other CSO, undertook, empowered the magistrates in various divisions of Lagos State to visit the police stations. And when they got to Zone 2, ONIGAH, on the 18th of May, they were denied access. From the reports made to us, the Deputy Commissioner for Administration refused access to the team led by His Worship Mr. Paul Damola, and that all entries made by the OC Lega of that zone fell on deaf ears. And I want to say this, that the magistrate need not, by the law, the magistrate need not apply or write to any police station that they are coming on a visit, because Section 33 has made it clear, that is Section 33 of the ACJL of Lagos State, and indeed of all other states, and Section 70 of the Police Act made it clear that magistrates have the power to visit police stations at least once a month, which means that the magistrates are supposed to be visiting even more than once. However, I just want to give, I just want to believe that these are transitional time, because before now, police think, or they always thought that they have all the, nobody controls them. But the ACJL has made provision for magistrates to oversee the actions and attitude of policemen with respect to detainees in their station. So much so that when the magistrate appears before, when the magistrate goes to the police station, the magistrate has the right to inspect himself, the magistrate has the right to look at the record of detainees, and has the right to grant bail there and then, or refer the matter to court for the detainees to be granted bail. So I want to use the opportunity to tell the police, particularly that Zone 2 and all of that police formation around Nigeria, that it is very, very legal for any magistrate as empowered by law to visit the police station, to grant bail or inspect their cell. The right to detain citizens of Nigeria without any supervision has been taken away by the provision of Section 70 of the Police Act and Section 33 of the ACJL of Lagos, which is also replicated in all the ACJL laws of the several states. So this is a way to discongest police stations from time to time and stop the police from oppressive detention of citizens of Nigeria. And we must now take the step to ensure that these laws are obeyed. And I want to say that the NBA, under this administration, we are determined to ensure that this law come into force all over the country and enjoin the chief judges of all the states of.
Thank you, Mr. Martins. Let me bring it back to you, Bernard. And I would like to stay with the issue of the Judicial strike in particular. Why has it lingered this far? If Judicial, you say, is on the strike, is on the part of the Constitution, and financial autonomy, of course, is described in the Constitution, why has it taken this far for this action to be taken? And then just add to that, this noble idea by the NBA, who are the detainees that are to benefit from this administrative bail initiative?
Well, from your first question, let me answer by saying that if the governors today and at this time chose to go by the provisions of the Constitution vis-a-vis allowing the head of the judiciary in their respective states to take control and take charge of their budgeting, the strike action will be called off immediately. You should realize that the members of the Judiciary Staff Union are not excited being on this strike. It's having a toll on lawyers. We cannot go to court anymore. It is unheard of. It should not be said in a democracy that the judiciary went on strike. It is like an entire arm of government not being available, and the judiciary cannot function effectively in that light. I am hoping that as quickly as possible and as urgent, and that the governors would see this as a matter of utmost public urgency and importance, to to make a public statement that they are going to adhere to the provisions of the Constitution, and Jusun will call off the strike immediately. Nobody is excited, like I said, being on this strike. Let me also address your second question on the noble initiative of the NBA. It is an initiative, yes, but it is also a provision of the law. It has not been adhered to all the while, but we want to let the Nigerian police know that we are now ready to adhere to Section 33 of the ACJL that allows chief magistrates to visit police stations within their jurisdiction at least once a month. So there's even a duty also on the judiciary vis-a-vis the chief magistrates to ensure that they make a visit to every police station within their jurisdiction at least once a month for purposes of inspecting the cell. One of the issues during the NSAS saga, which is still ongoing, is illegal detention facilities. A lot of Nigerians complained that they were taken from the usual police cell to houses outside the police station. We want to be sure what the police are doing. The people in the cell are brothers, our sisters, they are relatives. And so it is to ensure checks and balances. And I think it is high time the Nigerian police realizes the fact that we, the Nigerian people, would want to call them to account. And the Nigerian Bar Association, which is the watchdog in respect of protecting human rights and the rule of law, we are awakened to our responsibilities, and we will protect the Nigerian people. We would not give notices because we are not expected to give notices to police formations. We are expected to show up there, introduce ourselves, provide proper identification, and the police officers on duty have a duty to allow the chief magistrates, alongside members of the Nigerian Bar Association, human rights committees of those branches who usually would accompany the chief magistrates on such visits, to inspect their cell. So I would like to sound an alarm that the Nigerian police force should get used to this exercise. It's not only going to be during the pendency of the strike; it's going to continue because it's one of the ways we want to check the excesses of police brutality across the Federation.
But there's a question about the detainees who are to benefit from this administrative bail.
Very important for those whose offenses are bailable by the provisions of the law. You would enjoy the benefits of this visitation. And so what we basically do when we get there is to ask for the list of detainees, and we inspect the cell, and we interview them one at a time. We look at the police records, and if the offense is a bailable one, right there and there, the chief magistrate has the right to grant bail subject to terms and conditions. You know, that is basically administrative bail in that regard.
Okay, in case we have a bit of time to ask one more question, may I direct this to Mr. Martins if he's there? Okay, Mr. Martins, your colleague was stating that this is a transitional time. Even this laudable initiative is a transitional initiative. So would you then apply the same rationale to the issue of the independence of the judiciary? Would you permit the governors to negotiate something in between, briefly?
Of course, constitutional positions are non-negotiable. So there's nothing to negotiate. I think what is ongoing, because I've taken part in the talks, is implementation, how it can easily be implemented, so much so that we are not going to go back to this situation maybe in the nearest future. Because you must understand that the governors, they are also transitional. At the highest, a governor stays in office for 8 years. What if a governor who is inclined to obey now leaves, and what happens? So they are trying to put a framework to ensure that for all time, no governor can again deviate from obeying the Constitution. That is what is to be discussed. It is not to be negotiated whether or not the monies meant for the judiciary should be paid to the head of judiciary as a first charge. It cannot be negotiated. That is what the law says, and that is what the High Court held in the case of Jusun against the governors. So simply obey the law. Nothing. So the problem why we are at home, why the judiciary has been shut down, it is because the executive, the governors, have refused to understand the need that judiciary is not under the executive.
Right.
That judiciary is not a department.
Thank you so much.
Until they understand that, we are not going to move forward.
Thank you so much, AIKPOKPO Martins and BENARD ONIGAH, for coming on the show.